Hi everyone, this week's video is on the subject of settlement agreements, so documents which are used to often end on a mutual basis the employment relationship. The benefit to the employee tends to be a slightly higher payment in return for the benefit to the employer, which is certainty and finality in terms of protection from employment claims. We have a recent case which demonstrates the limitation of settlement agreements. So this relates specifically to the limitation that settlement agreements can only compromise claims which are in existence or in contemplation by the parties at the point of signing that agreement. So we have Bathgate and Technip UK Limited, which creates the principle that settlement agreements, or confirms the principle rather, that settlement agreements cannot prevent future discrimination claims. In this case, the employee had been a ship operator for 20 years before accepting voluntary redundancy and signing a settlement agreement. At the time of signing that agreement, the claimant was 61 years old. Included in the agreement was a clause compromising future claims against his employer in exchange for certain payments to be made to him. Now, quite unusually in this case, there was reference to a future payment which will be made to the employee, but which was quite uncertain at the point of signing the agreement. There was a historic collective agreement in place, and the employer essentially said, when it comes to 9 or 12 months' time, there is a payment that is due potentially to you, and we'll calculate what is due on the basis of the criteria that we apply at the time. Now, when it came to calculating that payment, the employer actually determined that nothing was due to the employee because he was under the age of 61. The terms of the collective agreement stated that anybody who had reached that age would not receive the payment, and thus the respondent said there was nothing to pay to the employee. The respondent had to accept that the claimant's age was the reason he didn't receive the additional payment. That derived from the collective agreement which set out those terms. Now, the tribunal at first instance said, well, hang on, he signed a settlement agreement, you've compromised your claims, and we actually have no jurisdiction to hear the claim. However, the Employment Appeals Tribunal and Lord Somers stated that the Equality Act specifically restricts the party's ability to contract out of a claim for discrimination when he did not know that such a claim was in place. Now, the Equality Act requires that for a settlement agreement to be valid in relation to discrimination claims, the settlement must relate to a particular complaint. A particular complaint is interpreted as one being which is in the party's contemplation at that time. So this does highlight that if we are using settlement agreements to compromise employees and their claims, we have to be aware of the limitation that it can only restrict claims that are in existence at the point of signing. This does bring us on to another practical issue, and one which is much more common in employment scenarios, and that is where there is a period of time between signing the document and termination. So a senior employee, for example, may be on 6 months' notice, and we've agreed that we will put a settlement agreement in place which is signed on a particular day. What we then want to do is place the employee on garden leave for 6 months, and he then leaves and takes all his payments. The difficulty there is that if there is no reaffirmation of those terms on termination, a claim could arise, and because it was not in contemplation at the point of the employee going on garden leave, technically those claims might not be covered by the agreement. Best advice in those circumstances is, at the point of termination, the employee is required to reaffirm all of those promises and all of those warranties that he has no claims and that he's signing away his rights in return for the termination payments, which is of course the employee's motivation. Hope you found this video helpful. If you do need further advice from us, please do visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.